All right, you can begin.
Thank you for allowing me to speak with you this morning about my candidacy. I just want to start by saying how happy I am to be in this building again. First, the fact that we're in person again. Second, when I worked here as a staff attorney for the Court of Appeals right after this building was opened, one of my other duties as assigned was to be a tour guide. And I would lead tours of children, business folks, 4-H groups, FFA groups, and point out the features of the building, how much it cost, the fact that the lottery paid for it, so our stupidity tax built this building. But one of the things I like pointing out is the public art. And there's a piece of art in the vestibule leading into room 165, where Justice has just rendered her verdict. And there is a winning side and a losing side. And the losing side is being consoled, and the winning side is not spiking the ball. It is a very dignified portrayal of Justice, because Justice in that painting has a very light footprint. The case is over. She is no longer involved. The ball is, to carry a sports metaphor forward, the ball is back in the court of the litigants. I think the best judges are those that model their judging after the painting outside of room 165. Light footprint, respect for the dignity and the decency of the litigants, the fact that every attorney is important, every litigant is important, and the most important people are the ones currently before the bench. As far as that transaction has occurred, the least important person is on the bench, because after the decision is over, the judge, the justice, the panel, they delink from it. But the consequence of that decision, days, months, years into the future. So professional humility, understanding that the judge will resolve this problem, but not own people's lives, that it is not the decision of a particular judge, it is a decision of the court for an individual in a contested case. With that being said, two examples of where I think that a light footprint could possibly be beneficial to the Court of Appeals. First, I think the Court of Appeals sometimes overwrites, in that there's diminishing marginal utility. With every additional word, at some point you achieve peak explanation, and each additional word detracts from the authority of the opinion, detracts from the message. It becomes the distinction Nate Silver would draw, that becomes less signal and more noise. And I believe that the Court of Appeals could write less, modeling after what President Kennedy said, never speak unless it improves the silence. Each word in an opinion should be value added. Less can sometimes be more. There are certain cases where I think more exhaustive explanation might be in order. If somebody's going to spend the rest of their life in the custody of the state, in prison, if somebody is going to have their parental rights terminated and that relationship be severed, there's some emotional toll in that might require longer writing. But otherwise, I think stepping back and understanding that more can be less. Another example where I think maybe more writing might be necessary is the occasional case that's transferred to the Court of Appeals that actually has an open question of law, where the Court of Appeals is asked to resolve a conflict or fill in a gap, resolve existing law, a case that might probably have been better retained by the Supreme Court in the first place. But things happen. Cases get transferred from this floor to the third floor, and the third floor of the Court of Appeals must resolve what is transferred to it, even if it involves novel questions of law. The second project that I think the Court of Appeals or the judicial branch as a whole might be interested in entertaining, and I've experienced this as an end user, and that is appellate mediation. I've had 2 cases in the United States Court of Appeals for veterans claims that settled pre-briefing. That court has a rule requiring pre-briefing settlement, and 2 of the 4 cases I've had in that court have resolved. I did not need to brief the case. The Secretary's General Counsel did not need to brief the case. It did not need to be assigned to a judge. And most importantly, the claimant, the veteran or the veteran's surviving family, got their hearing before the veterans law judge sooner rather than later. My application looks a little bit different than others because of my 14 years with the Iowa Department of Education, an extensive amount of government practice, learned quite a bit from that, that I think might be value added to the Iowa Court of Appeals. Application speaks for itself, and I'm more than willing to answer any questions or address comments or address insults that you may have about my application.
Thank you. We'll start with Commissioner Spees.
Good morning.
Good morning.
Mr. Mays, first of all, I want to commend you for your experience as a staff lawyer for Iowa Legal Aid. It's an organization dear to my heart, and my hat's off to you for that. So my question is kind of tertiary to that. Is there a role for compassion in an appellate judge?
I think that goes there's a role for compassion, and that's reflected in humility. That the judge, the panel, the combined wisdom of the panel is still not going to know everything that happened in the litigants' lives. But there needs to be some professional distance. Compassion cannot override. One of my heroes and one of my first mentors told me to never care more about my client's case than my client herself or himself. And so at some point, compassion can temper, can inform, but it always must be a piece of, but secondary to application of law to fact.
Thank you.
Commissioner Roberts.
Thank you. Good morning.
Good morning.
So you have described your practice. You're working in the Department of Education. I think according to the Court of Appeals published statistics, I think during 2021, approximately like 80% of the docket seemed to be either in a criminal law matter or a family law matter. So given that, you kind of mentioned that you really focused in education. Talk about, any sort of hurdles you might face transitioning from your current practice to coming onto the Court of Appeals with new areas of law.
I had 7 years at Iowa Legal Aid where about a third of my case law was family law. About a third of it, and within that third, ranging everything from child support modification, establishment and disestablishment of paternity, contested divorces, had a couple of interstate matters involving I think it is the UCCJEA. So I think I've got some fluency with family law based on my prior life. As far as criminal law, although I never directly represented a criminal defendant or prosecuted a case, many of my cases involve collateral matters where the legal matter or the factual matter involving my client's issue at Iowa Legal Aid and their case in criminal court, the Venn diagram might have been a circle because the facts are so closely related. As far as prior background that might help me transition into that role if I'm the successful candidate, serving as a staff attorney for this court, for the Court of Appeals for 2 years, saw many excellent criminal law briefs, many excellent criminal law oral arguments, and although I've had a niche practice area for 14 years, I was a committed generalist before that.
Thank you.
Commissioner Parrish.
No questions, thank you.
Commissioner Harkuff.
No questions, thank you.
Commissioner O'Brien.
I really like your suggestion about mediation at the appellate level.
Thank you for that.
And that was one of the reasons I selected that particular writing sample, to show sort of my fluency with alternative dispute resolution theory.
Thank you.
Commissioner Graber,
No questions.
Commissioner Stanger,
Thank you. Good morning.
Good morning.
Thank you for your application. It's refreshing to see some diversity in applicants, and I'm really grateful that you stepped forward for this. So my question is, why now? Why this position?
Well, I've applied twice before for the Court of Appeals. Both times the toothpick didn't come out clean. You know, I wasn't ready. The first time I was in my 30s. The second time I was in my 40s. Now I've been promoted to my 50s.
I like that.
And so it was really for the experience of it to go through this interview process. I've been through this twice before. It was combined the most terrifying 40 minutes of my life. Now I think I'm more, it's been 25 years since my judicial clerkship ended. I've been around a bit more, know a bit more about myself. There were some vacancies which I did not apply for because I felt my professional obligations would not allow me to even focus a moment on anything other than my work for the Department of Education, especially the vacancies during COVID. So now school year is the work associated with the start of the school year has peaked. It was it just synced up. It was the right season in my life. It was the right time where I felt that if I was a successful candidate, it would be a cleaner break than prior vacancies with my current position.
Thank you.
Commissioner Henderson,
No questions, thank you.
Commissioner Hoig,
No questions, thank you.
Commissioner Bevel.
Thank you. Mr. Mays, you referenced the term value added in your education work as it would relate to the Court of Appeals. Could you help us understand what you mean by that?
Well, there's quite a few contexts that I could have used that term in. Value added in a couple ways. First of all, many of the legal problems that folks get into are like a direct result to a poor education. The inability to calculate an annual percentage rate in signing on to your check at the check cashing store, or the APR at a title loan place, or not reading things is not just a function of a poor education. Educated people do it all the time, but the inability to read a lease. So that understanding that the long cascading ripple effects of a lack of education, how schools and education can be drivers to economic growth. Education expands the lifespan. If I have an education, it's a quality of life and a human life issue. If I have a adequate education, I will live longer than somebody who does not. I have better opportunities. I have better information to make better choices. So that's how I feel education adds value. My knowledge to society, my knowledge of that and education issues would add value to the court.
Anything further, Commissioner Bevel?
Oh, no, I thought we only get one. I don't want to turn it
Commissioner Hanson,
Thank you so much for applying. What is the most challenging litigation you've ever handled, and why?
It's not in my application because best foot forward, but it was very, very challenging to represent an individual who was on the sex offender registry in a landlord-tenant dispute in rural housing in Northeast Iowa. He was there first. There was no children living in the complex because it was senior housing. A neighbor across the street took in a grandchild for foster care or involuntary. Some family circumstance led to a neighbor having a minor child within 2,000 feet. And the landlord decided to terminate my client's lease because he was, I still don't believe it, air quotes, a clear and present danger. And I thought he was there first. He thought he was there first. Why should a change in some other family's compensation or family's composition cause him to lose housing? So took that case through unsuccessfully the magistrate, district associate judge, and applied for further review in the Supreme Court, or discretionary review in the Supreme Court. Always hard to represent individuals who are on the registry, but I thought his case had merit. I gave him my best effort. It was unsuccessful. I'm proud of the work I did for him. I would not want him living next to my family, but he deserved my best effort in his days in court.
Thank you.
Commissioner Gray,
I have no questions, thank you.
Commissioner Picklap,
No questions, thanks.
Commissioner Pearson,
No questions.
Commissioner Chase,
Thank you for your application. I don't have any questions.
Commissioner Hoiting.
No questions, thank you.
All right. Thank you, Mr. Mays. We'll be deliberating your application later this afternoon.
Thank you. Have a good morning.
Thank you. Thank you.
Never do that.